A man stands accused of laundering hundreds of thousands of dollars. The judge carefully questions every step of his plea, while the defendant admits to giving up his rights. But just when the punishment seems clear, confusion over probation and deferred adjudication throws the courtroom into tense uncertainty.
All right, court is going on the record. Court is calling 2025 CR 1023, State versus Mark Lunsford. Can I have parties announced?
Austin Stout for the state.
Dan Coggo and Sam Log from the Clubs.
And are you Mr. Lunsford?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Lunsford, did you review the application for deferred adjudication or community supervision with your attorneys?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, sir.
Counsels, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, except the state does have a motion to waive counts 2 through 55 and proceed only on count 1.
Any objections?
No, ma'am.
Mr. Lunsford, did you review the document entitled, just one moment. Did you review the document entitled Court Admonishments with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with money laundering? Everyone, please whisper. Did you understand you're charged with the offense of money laundering less than $300,000 as a first-degree felony? Range of punishment is anywhere from 5 to 99 years in life and up to $10,000.
The courtroom begins with formalities. Mark Lunsford confirms he understands the charges and signs off on the paperwork. But notice how calm he seems while the judge explains the risk. Life in prison, if this plea ever collapses. Would you stay this composed hearing those words?
Fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
We discussed the defenses with it, Your Honor.
All right. Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Lunsford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a United States citizen, by entering into this plea bargain agreement, you can be deported, not allowed naturalization or re-entry into the United States?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, Your Honor.
The prosecution makes its move, dropping dozens of counts and focusing only on count 1, money laundering. That sounds like a gift, but the punishment range is still devastating, 5 to 99 years. It's a chilling reminder that even a single count can carry a lifetime of consequences.
To the plea bargain agreement, the state is proceeding on count 1. They're asking that your punishment be assessed at 10 years in the prison. There's a $10,000 fine. State is opposed to your application for deferred adjudication. There's to be restitution in the amount of $297,276.34. And you will not accept or maintain employment in any position involving the handling of financial transactions. Counsel, could you all check the box here and
Yes, sir.
initial? Did you understand that to be the plea?
Sure.
Defense, is that the plea?
With the caveat that the state was going to recommend probation. Thank you.
No, they recommend probation, but they're opposed to the deferred.
Yes, ma'am. You just.
Sorry.
You said they're opposed to defer.
All right. So did you understand that to be the plea?
Yes, sir.
Do you understand that the state is opposed to your application for deferred, but they are recommending community supervision?
Yes, sir.
So do you understand if the court does not grant your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement? Do you understand? All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you?
Here's where it gets tricky. The defense expects probation, but the state pushes back hard against deferred adjudication. For viewers, this is the legal chess match. Probation means supervision, while deferred adjudication could eventually erase the conviction. The judge presses to make sure Lunsford understands the stakes. If you were him, which outcome would you risk? Probation with restrictions or deferred with the chance of freedom?
You understand?
Yes.
Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be 200 hours of community service restitution, a cap of 60 days in the Bexar County Jail, no contact with the complainants listed, and felony anti-theft course in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to count one, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
The state is offering State's Exhibit 1 and all attachments. And Your Honor, I would just want to clarify for the record that count 1 is first degree felony, but it is for money laundering over $300,000, not less than.
All right, thank you. I think what do you call it? The sign is incorrect. You know, when they do the sign, the less than sign and the more than sign. All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Sure.
Did you understand it and sign it in all the appropriate places?
Yes.
And counsel, I'm assuming you have no objections to the stipulations being entered?
We do not, Your Honor.
All right. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses?
Lunsford finally enters a plea of no contest. This is powerful. He isn't admitting guilt, but also isn't fighting the charge. It signals surrender, a way to avoid a jury trial. The courtroom tension spikes as the state introduces evidence, correcting the charge to laundering over $300,000, making the crime heavier than first described.
Statements and police reports, but most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, there's a stamp over the discovery.
I saw that too, Judge, a postage stamp. That made its way into the document. I wasn't sure what that was
So I'm not
about.
able to read that. If I lift it, it tears.
I can get another copy, Your Honor. It's going to take me a little while.
All right, no problem.
Okay.
And this is why I took math in school. So Mr. Lunsford, what's taking the court a while is that because this is submitted to me, I have to find that there's sufficient evidence to find you guilty. So I have to do my math to make sure this adds up. All right? All right. After reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We'll come back here for sentencing on October 20th. Your court date will be at 9 a.m. I will base my decision upon any evidence that's presented.
Sure.
All right. Anything else before we go off the record? All right. Once you sign the reset form and speak with probation.
The judge meticulously reviews the evidence, even cracking a joke about math while adding up the numbers. But behind the humor lies deadly seriousness. The court must confirm the paper trail proves guilt. Finally, the judge announces there is sufficient evidence to convict. Mark Lunsford's fate now hangs on sentencing day. A guilty finding is deferred, but the evidence is locked in, and the punishment could stretch from probation to life in prison. This case shows how even plea deals leave uncertainty, and how Quickly, expectations of leniency can clash with the state's hard line. Justice here isn't final yet, but the risk is real. What do you think? Was no contest the right move, or should he have fought the charge? If you found this case as intense as we did, make sure to like, share, and subscribe for more real courtroom drama. Every case reveals not just the law, but the high stakes of human choices.